Morning, we did.
All right, that's you, sir?
Yes, sir.
In 24 CR 10005. You have been indicted for the second degree felony of fraud using apparently fraudulently using identifying information of an elderly individual, namely credit cards, debit card, social security, driver's license, without the consent of the elderly person. So if convicted, you are looking at no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. Do you understand what you're charged with and the punishment range applicable if convicted?
Yes, sir.
It doesn't stop there. I'm looking at page 2 of the indictment. People in criminal law are punished based upon the circumstances of the crime and criminal history. You've got a rich criminal history. I'm looking at a burglary of a motor vehicle conviction. You're going to interrupt me? Well, let me speak and then you can talk. This states that on paragraph 2 of the indictment that you were convicted in 1990 in this court, and I was just a youngster, I guess, of burglary of a motor vehicle. Thereafter, that was fine.
Well,
The next paragraph, the next paragraph, paragraph 3 states that you were on January 24th, 1991 in this court, cause number 55194. It says you were convicted of of sexual assault, a second degree felony. After those prior convictions were finalized, paragraph 4 goes on to state that you committed the offense of aggravated robbery, a first degree felony, and you were convicted of that in 2004 in the 252nd Judicial District Court next door. What this means and how this affects you is if all of this was true, you are deemed to be an habitual felony defendant, which means you are looking at the punishment range now for you is not less than 25 years in prison. That's the minimum, up to life in prison. Do you understand what you're facing? Oh, now, Mr. Dusler here is representing you. Are you employed somewhere?
no, sir. I was at Jack in the Bus, but they never did call
I
me.
can't hear you, sir.
I said I was at Jack in the Bus, but they never did call me.
When was the last time you were employed?
Was it? Was it great?
Why? Why aren't you working somewhere? Is it because of your criminal history?
Yes.
But okay, so how do you exist? I mean, you got to eat and sleep and things like that. Where do you, how do you pay for?
It's hard out here.
Sir?
It's hard out here with you. It's hard out here.
Yes, sir. Well, I can imagine it is. But how do you do it if you've got zero income? I don't understand. How can you do that?
It's what I'm saying. I've been no dash, kind of small.
Where do you live? This says Sunbird Lane. Is that a home, a house
Yes, with my mom.
with your mother?
Yes, sir.
Okay. Do you have a vehicle? No. How do you get around? Your mom drives you? Okay, food. Who buys that for you? Your mom?
Yeah, I get a welfare $291 a month. That's all.
Well,
But these charges I have against me right now in front of you, I took a purse out of the radio.
that's hold on.
Okay, but
Yeah, we don't want to.
well,
There's the prosecutor. You start volunteering anything, he can use it to help his case. So talk to him. There's your confidence man right there, your attorney. But a case gets investigated by the police, then it goes to the district attorney's office. They review it. If they accept it and feel like it's worthy of moving forward, if it's a felony, it goes in front of the grand jury. And then the grand jury makes the decision. So don't be blaming him. It's gone through 3 sets of reviews, and here it is. Now it's in my court. So what we do is 2 options. We'll try the case in front of a jury, or it gets disposed of in a way without a jury. Most cases are that way anyway, by agreed dispositions. Here, once again, if the problem you have is any crime that's a felony above a state jail felony that you commit, you're looking at the rest of your life, no less than 25 years up to life in prison. But there's a way to avoid all of that. Is don't get in trouble, and make the right choices. Also, when was the last time you said you had an income, though? I mean, people are here in front of, I've got thousands of people. I've got 2,500 defendants at any given time here. And some of them are just like you, sir, but they're working. They're working. Very few are. Hold on, you get a chance to speak. When we both speak over each other, the court reporter can't take both people speaking. And the Supreme Court has said if the court reporter is interrupted, somebody gets in trouble. It's not going to be me. Now, so, because I'm not going to speak over you, but those are the rules. And it's a rhetorical question. Just people are here and they're working in spite of the criminal history. They find work. You got to find work. It's to make yourself independent, not live off your mom. I mean, that's brutally honest, but it's the way it is. And people are working who have criminal histories like yours in this court because they are hiring lawyers too, and they're not dependent upon others. You seem like you're healthy. You ought to be able to find something if you really want to be independent. That's my statement. All right. So Mr. Dusler is a very good lawyer. He's one of the public defenders, and he's going to help you on this case. And you have to know this is a most serious situation when anybody's looking at up to life in prison. And that's what happens when you have a criminal history like this. Any third-degree felony or above puts you in harm's way of life imprisonment from here on. That's why the best thing to do is stay away from trouble. Now, I'm going to let you talk to him, and we're going to, so you can, have you ever talked to him yet? Okay, meet him here in a little bit. He'll discuss some things with you. He's a smart man. It'd be wise to follow his advice, but it's at the end of the day, your choice. This is the kind of thing that may be workable. I'm looking at the facts of this case, and maybe there's something that everybody can agree on. If not, that's what jury trials are for, and we tried 600, so we like trying cases. But talk to him, then he'll get back with me, and we'll decide what the next step is. Okay, thank you. Just stand by. And okay, you're Joey Childress? Yes. Okay, in 25 CR 314, you heard all that. You've got an unlawful possession of a firearm by a felon charge here. Yes. That's what you're charged with on or about December 6th of last year. And a third-degree felony, if convicted, that's what this is, a third-degree felony. You are looking at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 could be assessed. Do you understand? Yes. But paragraph 2 states in 2012, in this court, you were convicted of injury to a child. So this third-degree felony, if this prior conviction is true, if you're convicted of a third-degree felony of this unlawful possession of a firearm by a felon, it becomes a second-degree felony punishment. It gets what we call enhanced, because like I told the gentleman before, you're your criminal law and dispositions, the way people resolve cases in criminal cases, they're based upon two factors: the circumstances of the crime and criminal history. So you would be looking at no less than 2 nor more than 20 years confinement in prison if convicted of all of this. Do you understand?
Yes.
So it's serious. Mr. Dusler, have you had a chance to talk to him at all?
Yeah, we spoke this morning.
A little bit. All right. And also for Mr. Anderson, as well as Mr. Childress here, if you want a jury trial, which you have a right to, if you're convicted, you are not eligible for probation in front of a jury. That would not be an option. It would be, if you were convicted, it'd be just flat time in prison. Have you not seen this probable cause?
Yeah.
Okay. You saw the bottom of it about the synthetic marijuana?
Yes.
All right. Have a seat, sir, and Mr. Dusler is going to be talking to you. In a little bit. John Laurie has been reset.
Yes.
Okay. Leonardo Mendoza.
That's the one that we discussed earlier. It's been reassigned to David Grove.
Okay, this,
Probation company and David's on that case, so I got.
you're representing Leonardo though, right? Mendoza?
Well, I was until now. He's been reassigned to David because there's no motion.
David.
Probation.
Okay.
Yeah.
He's going to have, okay, Mr. Grove then needs to be aware so he can help.
I need
Mr.
to answer
Mendoza.
keys and then I'll get.
The, on the NTRP is on the way. Okay. Clarhaney Milton?
I'll call the name.
Clarhaney Milton. I've never seen a first name like this. That's a new one. Clarrahnie. Clarhaney. And there is no answer here in the courtroom in cause number 23 CR 905. I asked the bailiff to call into the hall for Clarhaney Milton. There's no answer to that name being called into the hall. No answer to the name called here in the courtroom. Defendant has failed to appear. A warrant shall be issued for her arrest. What is her bond?
10,000 on it.
Okay, let's see. We've got actually 2 cases. 23 CR 905 is a state jail felony of forgery. And 23 CR 907 is a state jail felony of fraud. Each alleging on or about January 31st, 2023. The defendant committed these offenses. And so defendant has failed to appear in each of these cases. It's the bond is 5,000 on each case?
10,000.
10,000 on each case. These bonds are revoked as the defendant has failed to appear. Warrants shall be issued for her arrest. The bonds are now $20,000 on each case, plus the defendant must have a GPS device as a condition of bond. Does everybody see when these cases were indicted? July of 23. This is her initial appearance.
She just heard.
I know. I think a GPS device is very important on this one. You know. Wow, that's going on 2 years, and this is her first appearance. Interesting. Okay. Well, she's purportedly living in Port Arthur, but we'll see. Justin Moore, 3 cases.
All his name, don't you, sir?
3 cases are called 23 CR 1784, 23 CR 2027, and 23 CR 2028, the state of Texas versus Justin Moore. In each case, Justin Moore, no answer in the courtroom. I ask the bailiff to call into the hall for Justin Moore, please. The defendant is accused of the state jail felony of theft of metals in 1784, the state jail felony of burglary of a building in 2027, and the third degree felony of illegal possession of a controlled substance in 2028, but 2028 also alleges a prior conviction in 1997 of aggravated assault out of this court. What are his bonds? The defendant has failed to appear because there is no answer here in the courtroom and no answer in the hall by the bailiff call.
The 231784 is 5,000.
Okay, hold on. That
So that
bond is revoked. Warrant shall be issued for his arrest. His bond is now doubled to $10,000. Plus, he must have a GPS device, as to not three devices, but that will be ordered in each of these three cases he has failed to appear in. In 23 CR 2027,
7,000.
state jail felony of burglary of a building, $7,000 is his bond. It is revoked. It is now $14,000 plus, again, a GPS device must be acquired, and he must wear that as a condition of bond. And 23 CR 2028, the third degree felony of illegal possession of methamphetamine, which is enhanced to second degree felony punishment by the aggravated assault conviction alleged in paragraph 2 of the indictment.
15,000.
That's 15,000. It is doubled to $30,000. And he also must have a drug patch as a condition of bond as well. Drug patch, GPS device, and his bond is doubled on that case. Warrants are issued for his arrest on each case. It looks like John Overly, that was reset.
Yes, sir. He's in Jefferson County Jail.
Jefferson County, John Overly, that's three cases. And we go to Sean Wallace. It's on Sean Ray Wallace and what? Sean Wallace, Sydney Walker. Okay. Sean Wallace is called in 2157190. You are Mr. Wallace?
Yes, sir.
Yes, sir.
The defendant is present, and Ms. Holmes is present. His attorney, the state's attorney, and probation office official is present. The defendant has been on probation since 2022. I believe we placed you on deferred or unadjudicated probation January 27th. So that's about 3.5 years.
Yes, sir.
And you were placed on probation for 5 years for the third degree felony of assault, family violence. The court has received a report and also has received a motion for early release from probation filed on behalf of the defendant by his attorney. And the court has also received a report from Mr. Hill from probation on this case. Have you seen this?
No, sir.
Yeah. Here is what I highlighted in yellow, which I think is the bullet point on all of that, where the position is going to be that the probation office is taking on. You have earned reward, but the probation office, from his standpoint, feels like termination at this point ought to be kind of put on hold, but you would be placed on inactive probation, weaning you off for a year, seeing how you do. And if all is well there, we would reconsider this, and it would be obviously likely that you would be then permanent from probation, and this case would be then dismissed. The inactive probation consists of just a couple of things you have to do. And he'll go over that with you, but you're not going to have to do all that. You're facing, what is it, 30 some odd?
He's completed everything.
Yeah, 30 some odd. I think there's, you have, 34 conditions. And really, at the end of the day, what would he have to do in inactive? What would be his requirement? Just stay out of trouble, which is what we all have to do. And that goes without saying. But what are his affirmative obligations in an inactive probation?
Yes, sir. He's to commit no offense against this state, any other state.
I bet you he's going to follow that one.
Avoid injurious or vicious habits.
Okay. Yeah. I mean, these are all things all of us have to really follow.
Avoid persons or places of disreputable or harmful character.
Run with a good crowd.
Work faithful at suitable employment.
Are you working somewhere?
No.
Okay.
Well, the thing is,
You're trying to find
no,
that?
I had a job. I was working with Chevron on the third party company.
Yes, sir.
They changed some things within their ruling or whatever. And this came up, this case, by me being referred to the case, I guess the severity of the case, they had let me go because of this. And this is why I'm here today, to try to see if I can get off and complete so I can get back to what I do for a living.
Okay. We'll take it up. What else?
Support all his dependents, abstain from use or possession of any drugs, and never become intoxicated or under the influence of any intoxicating substance.
Okay. See, all of those are the conditions I have to follow too.
Yes, sir.
So there's no difference there. Now, on this job deal, and did you have a good relationship with the boss?
Yes, sir.
All right. Well, here's maybe the boss doesn't understand what inactive probation means and how that is different from active probation. That would seem to me to be a problem with a job.
It's the ISTC in the fleet. Okay.
So you can't have a pending charge. It's pending.
Yes, sir. And it makes it be a level 5, which in the state of Texas actually be a level 2 to migrate through different plants in Texas.
Yeah. Okay. What we're going to do is, look, go ahead. Did you want to say anything?
Yeah,
I have a plan,
okay.
but I want you to be heard in the state.
Well, we are asking obviously that we believe he's completed everything. He's been on for over 3 years at this point, on a 5-year deferred adjudicated probation, Your Honor. It is affected obviously with work. And so we are asking that if the court doesn't grant it today, that we not have to wait a whole year. Since he's obviously completed everything at this point.
Stay.
Your Honor, I spoke with Mr. Hill. I think he's also okay if he was terminated today. That was just a recommendation. I'd let him, speak to that. I think hearing this about the job issue, obviously would want defendant here to be working Mr. Wallace. And I think he has, according to Mr. Hill, he's done well on his probation. I don't think we'd be opposed to termination, but obviously I think Mr. Hill also said whatever the court.
I always buy into that, the weaning part of it.
Yes, sir.
I like that, the transition, but then again, it's specific to the individual and how they're doing. I mean, if they're doing well, reward the people. Would there be any objection if I followed the request of the defense and terminated the probation today and dismissed the case.
The only reason for my recommendation, Your Honor,
Yeah,
is
it's
the
good.
assaulting nature of the offense.
Let me ask you about that. That's a good point here. The, what's is this person's, the complainant here still related to you?
Well, she's my ex-wife.
Ex-wife.
Yes,
Y'all have gotten a divorce?
yes, sir. But we
Do
still,
you see her?
yeah, I have. We still co-parent.
You have a child
We
or
have two
two?
kids together.
You got 6 years.
We still co-parent.
How does that work?
Oh, it's better than ever. I mean, I had to do what I had to do, own up to what I did, and it's been great. I had to learn a lot of learning to do, a lot of growing to do, but
What did you learn? Because this is, I've never choked anybody in my life. I can't even imagine because, you know, it's brutal. Sometimes people lose their composure and lose their temper. But if you put your hands around somebody's neck and squeeze, there's only one intent there. I mean, that's to seriously injure or kill. And you don't do that to anyone unless you're defending yourself. Certainly someone you pledged love to. That doesn't make any sense at all. Because everybody's got good times and bad times in a relationship. We work through it without assault. Would you've been on this for longer than normal would be, but the criminal history kind of always finds people and that files you. That's why you want to avoid that. Criminal history, you got to carry that around your whole life. It wears you down. But this is, it's a disturbing set of facts. But probation office feels as though you're worthy. Everybody else does, so the court will grant the motion
Thank
for early release. I don't want to see you back in here.
I didn't know, Sue. And I thank you for the class.
I know, everybody says that, but really own up to the promise. Because I see people back here in spite of what they say. You gotta walk the walk, not just talk the talk, right?
Yes, sir.
Put this into action. Be the best person you can be. Follow the rules. And remember, assault, when you assault like your spouse or ex-spouse, your children, what are they going to do? You're role modeling all the time for your children, all the time. That's what a parent is. The example, the role model. What would you expect them to do when they lose their composure with someone, especially someone they pledge love to? You can't blame them if they start choking somebody. That you set the example. Fix that. Gotta always remember, it's not just your life on this planet. You brought people and children into this world, and you're responsible for the way they have become to a great degree. A parent is the most impressionable factor in a child's life. But you gotta act as though, I know you're nodding and you're saying it like this, but you gotta practice it every day. Okay. Anything else?
No, sir.
That is all. We'll,
The probation office will send it, email it to me and I'll get.
thank you, Mr. Gill. Thank you very much.
Thank you.
Let's see, Scott was reset. What, I have Sydney Walker. Sydney Walker. You are charged, ma'am, in two cases, 19-32373 and 32374. These two indictments. Good Lord, Ramped it up in 2019?
Yes, sir.
Wow. That's 6 years ago. Have you been living in the same place for the last 6 years?
Stayed in Houston.
Yeah. Okay, well, 2 million people. It's hard to find somebody if we don't know where you are. It's when you're in with 2 million people.
I was arrested for this in 2016, so I didn't actually know about the indictment.
No. You were arrested for this when?
In 2016.
No, you weren't. This says you committed this offense on May 25th, 2019.
No, sir, I was indicted.
This, ma'am, the indictment from the grand jury states this happened on or about May 25th, 2019. You can shake your head all day long, but it's not a debate. That's what the grand jury. I'm looking at the probable cause affidavit as well. This states on 5/25/2019. This is signed by the police officer who did this and sworn to on May 29th, 2019. There's nothing, you're wrong.
She was arrested for this type of offense in September 2016 for a separate charge at a Harris County judge.
Okay. Well, this has nothing to do with Harris County. This has everything to do with Houston Avenue in Port Arthur on 2019. This is 2 cases here charging you with the 2nd-degree felonies of assault on a peace officer. In each of these cases, alleged to have occurred on or about May 25th, 2019 in Jefferson County, Texas. It is alleged you bit the officers in each case, which wasn't a wise thing, if that was true. So in each of these cases, if convicted, you are looking at no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. So your punishment range is up to 40 years confinement in prison on each of these 2 cases. Do you understand?
Yes, sir.
All right. Are you employed somewhere?
Yes, sir.
All right. Are you getting a lawyer?
And I'm gonna.
You gotta have a lawyer. If you're working, I expect you to hire your own lawyer, and that's what people have to do. If they're in a mess, you have to fix it. You're responsible for helping yourself. Where are you working?
I work at Luby's in Houston, Texas.
At Luby's?
Yes, sir.
Oh. Let me just ask one question. Those chicken fried steaks and those fish, what's in that batter that makes it so good? No, I don't want you to, that's a secret. But I love that food. So what do you get paid?
$12 an hour.
Ma'am?
$12 an hour.
That ends up being about $25,000 a year. It's going to cost you more than this for a lawyer. I want you to fill out, you're going to sit over there and fill out one of those indigent forms, and we might be able to get somebody. Mr. Dusler is here. He's one of our public defenders. We might be able to get him to talk to you about this. First of all, this is this is very unusual. You never have cases that come in here 6 years old. When the rare event that we do, we have to move them along because they're too old right now. But that's what happens when you're in another city and you must have moved around. I've got 1755 Crescent Plaza as your address. See, I need to know. Stand by. I'm going to mute this for. Now I can figure this out here. I can find this out, but I'm going to ask you to help me right now. What is your criminal history?
I have a previous assault that was reduced to misdemeanor. I did 30
Where?
days, Harris County.
That one she was mentioning from 2016.
Is that it?
Yeah.
That's all?
And then I have something from when I was 17 in Mecklenburg County in North Carolina. I was, in, like juvenile jail. You know,
They
Carolina.
treated you as a juvenile, not as an adult?
Yeah, as a
You
juvenile.
sure?
Yes.
Because it will be found that if we can do the criminal history. I just
They did.
trying to think of, so you don't have a felony conviction?
No, sir.
Fill out, a indigent form. We're gonna get that for you. And fill that out and we'll review it. You swear to it. And then if I find it worthy, then we're gonna appoint you a lawyer to talk to you immediately, okay? Oh, and, Mr. Childress, come on up. You're, clear. Did you get a resetting?
Not yet.
You need to get a resetting.
And Judge, that's gonna go on trial docket and he's asking I be relieved.
Well, give, all right, he's not eligible for probation.
No, sir.
Sorry. What was the offer on it?
12 years.
All right. You understand, sir, you're looking at up to 20 years in prison on this. You understand? Okay. All right. And we're going to set it for a trial. That's what you want. There are no deals. Today's the day. That's it. We're going to move forward.
Yeah, he said.
We're going to move forward and, we're going to set it for trial and I'm not accepting that this is the time to negotiate the deal. So you passed that one. So, Mr. Dusler, he's a fine lawyer. He can, try it. It'd probably get to trial quicker if you agree to release him. The next person on the trial docket wheel would be, representing you. Is that what you want? That's the way it would go faster. If you want it to get to trial quicker, then I find good cause to relieve Mr. Dusler and the next person on the trial docket wheel, who are all qualified lawyers, will handle the case. And we're going to note this. This was the time to hold on for just a second.
Like I'm gonna give it like dozens of petty. That's like a good board, you know. We raise no products. That box says that.
That's
What box? What's that?
That lady right there, man.
It's only 2 piece officer. She lives in crazy.
You swear that everything you've written is true and correct to the best of your ability, then?
Yep.
You can just stand by.
Yeah, find the defendant,
Yes.
indigent under the examination here of the documents, and an attorney will be appointed to represent you, Mr. Dusler. I think he's working on the case right now. He's going to talk to you here in a little bit. Okay, just stand by. Thank you.
I can sit down.
Yes, ma'am.
I ever signed it.
Okay, so on, Ms. Walker, what are we going to be doing?
It's a plea on one case. and
Which one?
This is the first one, dismissal on the second one.
Okay, so 19-32373 and 32374 are both called the State of Texas versus Sidney Deval Walker.
Yes, sir.
You are Ms. Walker, present. With your attorney, Mr. Dusler, and the state's attorney, does the defendant waive a formal reading of these indictments and arraignments? Can we proceed in summary?
Yes, sir.
Then once again, the defendant is going to be entering a plea of guilty on 32373. And as part of the agreement, 32374 is to be dismissed.
That's correct.
All right. In summary, ma'am, in 32373, This indictment alleges that on or about May 25th, 2019, in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. Do you understand what you're charged with here in the indictment?
Yes, sir.
If convicted of a second-degree felony, you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range?
Yes, sir.
Okay, an agreement has been reached by the parties, correct?
Yes,
I
sir.
don't have a pass.
Yeah, we're working on it.
Okay, what is the agreement?
Deferred adjudication plus $500 fine.
Okay. The agreement is that you would be pleading guilty, not found guilty, but placed on deferred or unadjudicated probation, which can be up to 10 years in length. You do well, it's shortened to 1/3 of that. And $500 fine, and there will be conditions of probation, which would be normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
And also, as part of the agreement, 32374 will be dismissed today. So you'll only have to be dealing with one case on probation. How do you plead in this indictment? 32373, charging you with the second-degree felony of assault on a peace officer, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
I'm going to show you in a moment what's marked as State's Exhibit 1. I'm going to ask you if you reviewed that, you recognize it, that you discussed it with your attorney, and are the contents of State's Exhibit 1 all true and correct? Keep that thought. It's got to go from one computer pad to the next one and then to me.
Want to play the Jeopardy theme for me?
Would that make it go quicker?
It would motivate me, yes, sir.
Well, we found something that motivates you.
Well,
Don made me say that.
No, you
Don made
no,
me
he
say
didn't,
that.
Judge.
Mike
That was
did.
all. That was all on
Mike
your
made
own.
me say it.
All right, that's coming your way.
Thank you.
I'm pulling up the dismissal. We gotta get one document.
Okay. All right. Once again, Ms. Walker, how do you plead in cause number 1932373 to this second-degree felony of assault on a peace officer? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? Again, that is on your own free will
Yes, sir.
and because you are guilty.
Yes, sir.
Show you here. What's marked as State's Exhibit 1? Did you sign that document?
Yes, sir.
Discuss it with your attorney?
Yes, sir.
Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into
Have no
evidence.
objection.
Without objection, it's admitted. Among other things, this states you are mentally confident to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you were totally satisfied with the representation provided by your lawyer, Mr. Dusler. All true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived here. I'm going to follow this agreement, ma'am, if nothing further. I'm going to find that you are pleading guilty voluntarily, knowingly, intelligently. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. So long as you follow these terms and conditions of probation, you will be placed on deferred or unadjudicated probation. That means you're not adjudicated guilty, you're not convicted, but you will be under terms and conditions of probation. Make sure you follow those. That will be for up to 10 years, but we shorten them to 1/3 when people do well, 3 1/3. There will be terms and conditions of probation, which are normal and customary for this type of offense. You will be fined $500. Make sure you follow these. If you fail, your probation could be revoked. You could then be found guilty and sentenced to no less than 2 nor more than 20 years confinement in prison. So do well.
Yes, sir.
I've signed this and it is sent on, and the probation officer, that nice man, is going to go over those terms and conditions with you. I am looking at cause number 19-32374. There's a motion to dismiss that case, and I am signing that and ordering it to be dismissed. Okay. All right. Please see the probation officer. Thank you.
So this is your comment. Well, this is, yes.
All right. We are in